Hello and welcome to The Hindu for this special discussion. I'm Sandeep Phukan, and this week we will discuss the landmark Supreme Court judgment that said allocating work to prisoners on the basis of their caste is unconstitutional. To discuss this, I have with me my colleagues Krishnadas Rajagopal, who writes on legal affairs and covers the Supreme Court, and Abhinay Lakshman, who covers the Ministry of Social Justice and also writes on issues of social justice. Welcome to both of you. First, let me come to you, Krishnadas. It is amazing that even after 77 years, Supreme Court actually had to pass a law that said allocating work to prisoners is unconstitutional. First, give us a sense of how did this case land up at the Supreme Court?
When the Constituent Assembly started their debates, or the first thing that they focused on and they said that they have to get rid of is the caste system. They wanted to dismantle the caste system. That was one of the first steps that they took towards social revolution, as they said. This particular case started in July 2020 by this, the journalist Sukanya Shanta. She had a Pulitzer grant and she researched on jail manuals. And she understood that there was a lot of practices which was institutionalized in jail manuals. Terms such as scavenger classes, institutionalization of certain castes for certain jobs, segregation of work, labor, division of labor in prisons, habitual offenders, entire communities being branded as habitual offenders. And so there was caste-based discrimination, and this was recognized through the jail manual.
So the caste discrimination was essentially recognized by the state.
Exactly.
But this, as you said, this was in the jail, through the jail manual. But I presume these jail manuals would have been prepared, during the British era,
Yes.
And so it's essentially a colonial legacy that has continued.
Exactly. But then we have the 2016 Model Prison Manual, which is supposed to be heralded as a complete changeover, and then we have the 2023 Prisons and Correction Services Act, which was just last year, which in a way just brings on the same practices, inadvertently probably, or just out of habit. The same terms are used. I believe. Even the term caste-based discrimination within prisons itself is not basically, they've not touched on that there is a social evil within prison walls. So it was as if the colonial masters had left, but the stay layer of colonialism within prison walls.
So, what you're saying that even the reformative laws, which were enacted and as recent as last year, even they fail to detect or correct this...
They replicate. In a way, they replicate the same terms in certain conditions, and the same practices, the same the way of the attitudes are almost the same. So these are some of the issues that the petition highlighted and which was addressed by the court.
So coming to this judgment, the bench headed by Chief Justice of India made some very sharp comments. I was going through, in fact, your copy. What are the main features of this order? What do you think are, what do you think are the features of this order that stands out really?
In fact, let's look at certain articles that the court has focused on. Article 14, which is equality. Article 15 is caste discrimination. There should not be, no citizen should suffer from caste, religion, any discrimination of any sort. 17 is untouchability. They've abolished untouchability. But the court says that segregation of work is a practice of untouchability. It is also a form of slavery. And then, and then Article 21, which I think dignity of life, and you are branding entire communities as habitual offenders. You are saying that, right from birth, even their faith upholds criminality. And you're basically saying that criminality is hereditary. You had the Criminal Tribes Act, and then you replace it with the Habitual Offenders Act, and you are loosely calling communities and people individuals.
It's as if you're actually completely painting one entire community as a criminal class.
Entire community, wandering tribes, criminal tribes. I believe Abhinay would know more about it. So these are the highlights of this judgment, and every single one of these issues have been highlighted and dealt with by the Supreme Court in its judgment.
So landmark indeed. Abhinay, coming to you, as Krishnadas was saying, that even when there were laws regarding model laws regarding prison reforms, even they failed to actually detect these anomalies or colonial legacies, and in fact they ended up replicating them. This judgment in particular talks about denotified tribes being called habitual offenders. First, for the benefit of our viewers, you should explain what does denotified tribe means and the difficulty in definition of a denotified tribe.
Sure. So, denotified tribe, by its definition, was referring to the process. For instance, there was a law that was enacted under the British administration called the Criminal Tribes Act of 1871,
right,
which allowed law enforcement agencies to classify entire communities as either criminal or not. So that was coming from an understanding that criminality is itself hereditary to some communities. And so that law enabled law enforcement agencies to classify communities as such. So in 1952, when...
This was during the British era.
Yes.
This when the
1871.
Yeah, and the British rulers saw certain communities or certain tribes as tribes who were prone to committing crimes. And even if you try to reform them, they go back to their ways of crime.
Right.
And so it's basically completely classifying a community as a whole.
Right. From a very primitive understanding of how social behaviors work, this classification was made, classifying entire communities as prone to criminality. Now, obviously, when the Constitution was adopted and new laws were first starting to be made, in 1952, this was one of the first acts to be repealed at that point. So as a consequence, the communities that were notified as criminal under this act became denotified as a result of repealing the act. Hence the name denotified tribes. But the catch was that the operation of the Criminal Tribes Act in itself was very diverse, spread across regions. Some regions scheduled more communities as criminal. Some regions scheduled fewer communities as criminal, so on and so forth. So at the height of its operation, in Punjab itself, there were about 200 communities notified as criminal under this act. So at the time that the act was being repealed, there was a committee, also known as the Iyengar Committee at the time. And as a consequence of the resources available to them, they were able to record just 126 of these denotified communities, which included castes and tribes and other communities. Over the last few years, 70 years, successive commissions have been set up, which have all come up with different numbers of denotified communities, which were either classified as criminal before or now want to be counted as a denotified community. For instance, in 2005, a commission headed by Renke, B.S. Renke, had identified 334 denotified tribes. And following that, B.K. Date, B.R.A. Date, he identified about 425 denotified tribes across the country. And even his commission had gotten requests from 110 communities to be included as denotified tribes, claiming that they are being put under disadvantage like this. But what happened when they did away with the Criminal Tribes Act was they brought in something called the Habitual Offenders Act, which was also in 1952. And even though states and provinces had similar laws of their own, the object was to standardize a definition of habitual offenders, which the Act tried to do based on repeat offences. If someone has committed repeat offences in a given period of time, they can be classified as such. But as a result of law and order being in the hands of states over the years, the definition of habitual offender has been different, has been varying in different states' prison manuals.
But just hold on your thought here. So the Habitual Offenders Act,
right,
did they also identify communities as criminals, or was the focus on individuals?
So that was the salient difference. Habitual Offenders Act defined an individual who is an habitual offender.
Yeah. Because that's how I understood.
As opposed to which community is criminal. But the reading of the Habitual Offenders Act by law enforcement agencies in the states led to a varied set of definitions. For instance, the Habitual Offenders Act's insistence on focusing on an individual led to a provision in the Madhya Pradesh jail manual, for instance, which said that, okay, we will define individuals who commit repeat offences, but at the same time, it has a provision that says that any member, any individual of a denotified tribe can be considered a habitual offender.
Okay, so there's a grey area there. So basically, your focus, the focus is still an individual. Absolutely. But if he's part of a larger community or group that was once considered as a criminal group, then even then it'll be considered as...
They may be classified as a habitual offender. Now, as a result of this entire concept of a Criminal Tribes Act, that it is the habit of a community to commit crime, that idea is kind of reinforced in the way certain jail manuals define the habitual offender. For instance, in Tamil Nadu and Andhra Pradesh, it defined habitual offender in a way that made that provided for, using certain crimes like theft and robbery. Certain individuals are hereditarily prone to commit such crimes, as in they have a habit to do so. So this was some things that the Supreme Court judgment also pointed out, that you cannot ascribe crime as a habit to an individual. Nobody can be habitually, inclined towards crime or have a proclivity towards it.
So the next question that I wanted to ask you is that, as I said, this is a landmark judgment. There's no doubt about it. But, this prison, the management of prisons are being handled by state governments. So how does this actually translate on the ground? Because every state government will have their own list of habitual offenders.
Sure.
And as you rightly mentioned, history says that different states had different categorization of these criminal tribes, denotified, subsequently denotified tribes. So, can we have a uniformity of practice in terms of management of jails after this judgment? How do you see this translate on the ground?
There might be an effort to it, maybe in terms of definitions and how we may or may not define certain terms or classify certain prisoners. But beyond that, legislatively, I don't know, in the structure, it appears that jail management has always been part of law and order and, state subjects. So I do not know if it is possible to centralize prison management as an overall...
No, I didn't mean centralized prison management, but I'm saying that, this judgment sets certain guidelines.
Sure.
So, the way eventually it has to be implemented on the ground and by the respective state governments. So, do you think that every state government will take steps to correct it, or...
Well, they have been asked to correct it. They have been asked to...
You want to say something?
So there are 6 to 7 directions. Basically, they're saying that you bring out your compliance reports, and the court has taken suo motu cognizance of discrimination in prison system. So now we have the court having an oversight, and it has asked both the center and all the states and union territories to bring in their suggestions and compliance, file compliance. So this is going to be a continuing mandamus, Sandeep. So, and as they proceed, probably they will...
So, mandamus, for the sake of simplicity, mandamus, an ordinary viewer...
Oversight.
Yeah, so it's a direction from the court.
Yes. It's like the MC Mehta case, where trees are cut and there is the Himalayas, the ecosystem is degradation.
Yeah, so the Supreme Court will be monitoring the way.
To what extent and for how long, the court will now decide. But we will have the judiciary also working with the union and the state to see that discrimination can be
stopped
or trimmed at least.
Right. That brings me to this question, Krishnadas, that as a parliament reporter, I've reported, and even as someone who covers the law ministry, I've reported on so many bills that repeal old archaic laws. But it is incredible that this continued. And so can you think of some laws that have, that sort of continue even though there is no need for that law?
Well, there is a law that continues from our first revolt, 1856, the Hindu Widows Remarriage Act. That is, if the widows wanted to marry, they had to ask for permission, the Hindu widows. Then there is, I think, the Police Incitement to Disaffection Act, where if you try to incite a cop to work against his uniform duties, then you're committing a crime. So maybe these are some of the obsolete laws that are in the line for repealment. But I believe there are more than 1,500 laws which have already been
repealed. In fact, close to 2,000, if I recall correctly. Certainly more than 1,800 laws. So, I mean, it is remarkable that the Supreme Court took a proactive stance and, held this law, allocating work to prisoners on the basis of their caste as unconstitutional. But what is even more remarkable is that such a law continued to exist in independent India even after more than 7 decades of independence. That's all from all of us here. For more such videos, keep watching The Hindu.